This is a part heard appeal in the matter of Titanium Capital Investments Limited and another, and Hughes and others.
Miss Elliott.
Yeah, thank you, my lord. My lord, yesterday, my lord Snowden asked us some searching questions about business connection, which I think can probably be split into three for our purposes. Firstly, he asked what exactly did the judge decide with respect to business connection. I think secondly, he asked what on our case is the partnership's business connection. And thirdly, is ACON a business connection for the purposes of section 29? On those three topics, I will make submissions. But before I do so, I just want to remind the court again that it was never the respondent's pleaded case that the partnership's relationship with ACON was part of its goodwill. And one can see that most readily from paragraph 167 of the amended particulars of claim, which is at the core bundle 418. And you can see there...
Sorry, hang on.
Yes, sorry.
Give me the number page again, 167.
418.
418.
Yeah, yeah. This is the reply, in fact. In the reply, they set out what they say was the assets of the business, and they, admittedly they say included, but they say its rights under its exclusivity agreement and the letter of confirmation with ACON. If you remember, that was that had to do with an agreement that the partnership said it had with ACON that it could exclusively lodge a tender with the DHSC and no other distributor could. And then secondly, its claim against ACON under that exclusivity agreement, its brand name Hughes Healthcare and the goodwill associated with it, its correspondence records and its lists of customers and contacts, its cash at bank and in hand, rights against trade debtors, and its registered domain names such as hugheshealthcare.co.uk. So it was nowhere alleged that A, that ACON was a business connection, or B, that the relationship with ACON was part of the partnership's goodwill. And I would ask you to bear that in mind, because of course what we say is quite possibly and very likely, had that been the plea in the particulars of claim or even in the reply, we would have approached the trial in a different way. So it's and I say it's only in the last 6 weeks when Mr. VR was instructed as replacement counsel that this new argument has arisen. So what did the judge decide with respect to business connection? The judge addressed business connection at in tab 9 of the core bundle at paragraphs in 278 to 285, but in particular paragraph 279 and 281, and the core bundle starts at page 140, and at paragraph 279 the judge sets out what our closing submissions were on what business connection was for the purposes of section 29. Must have a character that is specific to the partnership. It cannot be the case, for example, because the partnership has purchased goods from a certain shop or supplier, that a former partner cannot purchase goods from the same shop or supplier. In order for the business connection to be an asset belonging to the partnership, it must have some character of exclusivity or a special relationship, such as a preferential price. Otherwise, it's not a connection or opportunity belonging to the partnership. He goes on, the judge says that that's an unjustified gloss. There's no statutory requirement for a character of exclusivity or any special relationship. Rather, whether something amounts to a business connection is a question of fact and degree to be considered in the light of all the relevant circumstances. And I think my Lord Snowden accepted that really before you get there, you really do need to nail down what a business connection is as a matter of law. And then he goes on and says that in my judgment, the relationship with Acon amounted to a business connection that consisted of the partnership's ability to purchase a highly regarded LFT from Acon in circumstances where most people who sought to compete with the partnership did not, because Acon was selective about who they supplied. The ability to purchase tests from Acon was the lifeblood of the partnership. I pause there to say the fact that something is the lifeblood of a partnership doesn't, if we're going to say it's goodwill, doesn't translate the fact that something is the lifeblood of the partnership into the partnership having goodwill with a supplier. And then Acon took steps to ensure that potential customers did not circumvent the partnership by its practice of referring back to the partnership attempts at circumvention. Acon was a business connection, even though the partnership did not, at least in Acon's eyes, hold any position as an exclusive distributor in the UK. What do we say our case is in relation to, well, you know, as things have moved on before you, my lord, my ladyship, you know, we were talking about whether business connection was goodwill and nothing more than goodwill yesterday, and I think both sides have gone away and had a look and thought about what goodwill was. Whatever business connection means, we say that the judge's approach was wrong, and we were broadly right in the analysis that the judge rejected at paragraph 280. And in that regard, we have, I think, both sides have had a look at the margarine case, which you very kindly brought to our attention yesterday afternoon, my lady. And of course, as you rightly point out, the margarine case is in sort of, I suppose, the first case where Lord Macnaghten in that case did seek to analyse what goodwill was. And he started at the bottom of page 223. I think that's in that's tab 4 of the Forstone, tab 4 of the Radcliffe Chambers new authorities, which I think have been handed
Have I
out.
got such a thing? Oh, I see.
So at the bottom of page 223, Lord Macnaghten said, "What is goodwill? It is a thing very easy to describe, but very difficult to define. It is the benefit and advantage of the good name, reputation, and connection of a business. It is the attractive force which brings in custom. It is the one thing," and I rely on this, of course, "which distinguishes an old established business from a new business at its start. The goodwill of a business must emanate from a particular centre or source, however widely extended or diffused its influence may be. Goodwill is worth nothing unless it has power of attraction sufficient to bring customers home to the source from which emanates." And I'll be taking you in a minute to some extracts from Linley and so forth that seems to approach the idea of business connection as being a business connection to customers rather than to a supplier, although the case that I'm going to take you to next, which is at tab 3 of the Forstone Buildings authorities, which I think have been handed up to you.
I can't see that.
No, they haven't been.
Oh, they haven't been? Oh, I thought they were being brought.
Well, they will be.
My mistake. I thought they were being bought.
Have we got?
Right, let's hand up our copies.
Have any of these been sent electronically? Because I would.
I think I can send you.
Well, if they could go to one of our staffs.
Yes. We've got.
hard copies won't be handed out. So, well, you just said it. Just explain the position to the court.
Oh, they, oh, right.
Mr. Crossley does have hard copies, so there we are.
Oh.
If someone could send both sets electronically, that would be helpful.
Yeah. So this is the Perkins and Sean case.
Right, so which tab is
That's
that?
tab 3 of the Four Stone Buildings Authorities. This was an interesting case because it concerned darts, and and also it's potentially relevant if it's considered that a supplier can be a business connection in the context of Section 29, because this concerned a supplier of darts, a type of dart which was called a pentathlon. You can see from paragraph 2, in the period 1987 to the middle of 2003, these darts were supplied by Retriever, the manufacturer, exclusively to the House of Darts business. And then, but then you can see at the end of that paragraph, the long-term nature of the trading relationship between Retriever and the House of Darts was never formalised. And then what happened was, at paragraph 3, the House of Darts business belonged to a partnership owned by two brothers, and then they want in 2003, so 16 years after Retriever had been selling these darts to the House of Darts exclusively, they retired and they sold the business to a Mr. Perkins. And then what happened is that Retriever didn't continue supplying Mr. Perkins when Mr. Perkins purchased the House of Darts business, and instead started supplying them to one or more other wholesalers. And this was a passing off claim by Mr. Perkins, which failed because the judge found that actually there was no misrepresentation by Retriever or any of the wholesalers when they were selling the pentathlon brand. But the bit that I want to refer to starts at paragraph 30, when the judge asked the question, have Mr. Sean and Retriever committed the tort of passing off? I begin with some general observations. Commercially, goodwill is recognised as a form of property, and transactions in goodwill occur constantly in all areas of business. The law also recognises that goodwill exists and affords it a measure of protection through the law of passing off. However, the degree of legal protection is not as extensive as the factual and commercial content of goodwill. To some extent, that is necessarily so, given the factors which make up the goodwill of a business or of a particular line of business. The essence of goodwill has been encapsulated judicially in Muller as the attractive force which brings in custom. To a large measure, it lies in the de facto expectation that an established line of business will continue, that the customers will carry on purchasing the goods or services, and that the suppliers will carry on providing the supplies which enable the goods or services to be provided. But those are not matters which can be given legal protection as some species of property right. The goodwill value of a business can be reinforced by making long-term contracts with customers or suppliers. But goodwill can exist and can have a significant value even in the absence of long-term contracts. In such cases, it exists as a commercial reality, although major elements of it do not and cannot receive legal protection. Suppose that a particular business has been profitable for years but depends heavily on one major customer, which is not tied in by a long-term contract. If the customer chooses to withdraw its custom, the value of the goodwill would collapse dramatically. But obviously, there could be no form of legal redress. A recent purchaser of the business may have paid a price which assumed that the customer would maintain its custom, but if the customer unexpectedly withdraws the purchaser has no rights against the customer, or for that matter against the vendor, unless the vendor had warranted that the customer would not withdraw. Similarly, and more appositely for the present case, if a profitable line of business relies in practice on regular supplies of goods or services from one supplier, but there is no long-term supply contract, the value of the line of business could be substantial. Yet if the supplier unexpectedly refuses to continue making supplies, the value may largely disappear. That too is not a contingency for which there could be any form of legal redress against the supplier. But I draw your attention again to the beginning of that paragraph, which is all based on the proposition that a particular business has been profitable for years and depends heavily on a major customer or a major supplier. So we do say, both in the Margarine case and in the Perkins and Sean case, what is significant, if you're going to be able to establish goodwill, is that you've got an established business with an established and long-term or longish-term connection with a customer or a supplier. And here, the business had been in existence for 7 months. And the proposition that the partnership was in a position to effectively attract loyalty, which is really what from this supplier, in circumstances where it had only been purchasing from that supplier for 7 months, is out with the authorities, and in our submission would not amount to goodwill.
So
Now,
can I just pin you
yes.
down a bit?
Yes, sorry.
So you're not suggesting that there can't be goodwill or connection in relation to a supplier?
No, but I will draw your attention in a minute to various various bits and pieces in the partnership textbooks and elsewhere that suggests that actually, I mean, if you're talking about connection, you're talking about broadly connections with customers rather than suppliers. But I mean, notionally, if one looks at the Perkins and Sean case, one can see that in the right circumstances, if you had a partnership that had been dealing exclusively for years and years and years with one particular supplier, and the partnership was dissolved, and then one partner sought to effectively procure a continuing supply from that supplier, that by parity of reasoning, I suppose, with the customer, that one could say that if Section 29 is goodwill, that there would be a duty to account. But we say, in this case, ACON, the partnership's relationship with ACON never came anywhere near that. It wasn't exclusive, as in the case of Perkins and Sean, and it had only lasted for 7 months. And just as importantly, if one says, well, which I think it can well be in relation to goodwill, that if you can demonstrate that a particular customer has developed a loyalty, or a supplier has developed a loyalty to a purchaser, that then in those circumstances you could say that the partnership has goodwill, has built up goodwill with that supplier or customer. But here we know that didn't happen, because what happened, as a matter of fact, is that although the partnership thought that they had an exclusive right to tender for contracts with the National Health Service through the DHSC, ACON permitted, I think, at least 2 other distributors to tender as well. So what price loyalty? I mean, Acon was interested in selling tests. One gets that, I think, from, well, first of all, if one just goes to the agreed.
The reason I think you talk more usually about goodwill attaching to customers is because it's a way of describing the tendency of customers to come and buy the products that you offer for sale.
Yes.
It's not normally the case with a supplier that you would say that you have goodwill with a supplier, because in a sense the decision about whether to go and ask them to supply is yours. And so, you know, it's really just the expectation they may be prepared to sell if you are interested in buying.
Yes.
Unless there's a long-term supply contract with either minimum quantities or something like that, as paragraph 30 says, you can protect,
Yes.
you know, goodwill or reinforce it by contract. But in that case, then that contract would become a piece of property.
Yes, absolutely. I think the reason why I'm happy I'm happy to concede that a relationship with a supplier could amount to goodwill is because the facts of this particular case, there was never any long-term contract, but they've been dealing together for 16 years, and also the original idea for and exclusively. So only for those 16 years, the manufacturer only used House of Darts to sell the darts, distribute the darts, if you like, to other distributors. And in those circumstances, I mean, and also this.
In this case, the goodwill was found to exist in the retailer, as I understand it.
Yes, it was. Well, not in the, well, in the,
In other words,
not in the supplier.
yeah, that's what I mean. As I understand it, the finding here is the owner of the goodwill was the retailer.
Yes.
Who had the goodwill of customers who came to the retailer to buy the flights.
Well, I think he does say at paragraph 31.
And you potentially have a saleable advantage.
Yes.
If you have at any rate, as you say, a long-term established relationship with a supplier who's going to supply to you and not to other people.
Yes, exactly.
So in that sense, it makes sense that it's an aspect of goodwill.
Yes.
It's something that you can value.
Yes, and you can say, look, I've had this 16 years long-term relationship, and in fact, the sale agreement between House of Darts and the purchaser did have that's why the purchaser was so upset, because he did pay for goodwill, thinking that he was going to be able to continue
the relationship.
Yeah, continue the relationship.
Just talking around things a moment longer. So, partnership is dissolved. You then have to set about winding up. Conventionally, one of the things you might then do is sell the goodwill.
Yes. And what we would say here is that, I mean, there was no prospect of any relationship with Acon being capable of being sold. It just wasn't. Not least because, and I know I keep coming back to it, is that by the date of the dissolution, the major contributor, almost not exclude, but really the major contributor to the turnover of the partnership was Newfoundland, who were then going direct to Acon. So overnight, its turnover was going to collapse.
Can I throw out two more red herrings?
Yeah.
One is, I'd be quite interested to know what pre-1890 authorities said about connection.
Yes.
Now, I see from the bundle we've got Willett and Blandford, page 74 of the bundle. I don't suggest anybody looks at it now.
Yeah.
There was reference to goodwill and connections.
Yes.
But I don't know if anyone has done a search in the partnership context to see how connection was used before 1890, because that could cast light on what people thought they were legislating for in 1890.
Yes.
But don't try to deal with it now.
Yeah.
But I'd be interested on both sides to know what the answer to that is. Secondly, I noticed in Linley, in a passage I think isn't in the bundle, this is paragraph, I may have lost the paragraph 10, no, that may not be the right one. 10.430.
It's not in the bundle.
I don't think it's in the bundle, I haven't checked.
No, I
Anyway,
don't think it is.
10.430, that explains that if you have a partnership post-dissolution that has no saleable goodwill, either partner can use the name.
Yes. Yes.
So notwithstanding section 29, there is some linkage between right to use the name and goodwill post-dissolution. And I wonder
think
whether...
we have looked at that, but we've looked at most things, but we'll have...
Yes.
What we could do in relation to that, because Linley says something at 1674 about exploiting the firm's business connection and treating it as effectively appropriating, well, if one goes to pay 1674 of Linley,
Yep.
and it's page 2432 of the, it's 106 of the bundle, tab 106, and I'll just, so, and if one looks at 1674, sorry, so in the second part, accordingly, a partner who exploits the firm's business connection in order to take on new business for his own benefit may be accountable for any profits realised, even though such business could not properly have been transacted by the firm without the agreement of all the other partners. And the footnote, what Linley says is conceptually this must be correct, because the partner in the example has in effect appropriated part of the firm's goodwill, i.e. customer connection, for his own benefit. And of course, you'll recall that in John Taylor's, we looked at paragraph 31 yesterday, where Lady Justice Arden said, likewise, the goodwill of a partnership, its business connections generally were an asset of the partnership. So she seemed to view business connection as something analogous with or similar to goodwill. And if we could just go back to John Taylor's and have a look at what the trial judge was recorded as saying, which is at tab 30, I think, the bundle. Paragraph 13, where Lady Justice Arden records what the judge did. He summarised the law, and applying the law, he held that there was a continuing fiduciary duty. He also said that there'd been a breach of duty to act in the best interest of the partnership in securing the temporary licence and in writing to the old customers of LLCA, that's the partnership, regarding the interim running of the market. He further held that the appellants were able to take advantage of the goodwill which the partnership had generated in running the market over many years. He also held that the appellants were very considerably assisted by the fact that they had the advantage of running the market in the interim from the 1st of January 1999, and he held that that advantage and the goodwill of the partnership were assets of the partnership, and that it was no answer that the respondents could tender for a new licence. He was less convinced about section 42, but a crucial ruling of the judge was as follows: I consider the defendants must account to the claimants for the benefits derived from the grant of the new licence to them, which, as I've indicated, resulted from the use by the defendants of the partnership's asset of goodwill and also its business connection with its existing customers. So again, the judge at first instance thought that it was a business connection with customers that was relevant under section 29, not, interestingly, a business connection with the council. But in fact, when one comes to look at what Lady Justice Arden said, is that she considered that the benefits derived the local authority was also a business connection. Because she says, I consider that the defendants must account to the claimants for the benefits derived from the grant of the new licence to them, which, as I've indicated, resulted from the use by the defendants of the partnership asset of goodwill, and also its business connection with its existing customers over a long period of time. But she also said that the connection that the partnership had with the local authority was also a business connection.
What did she say then?
Is that paragraph 30?
That's paragraph 31, yes.
All right,
Is
okay.
that very clear? That's why I'm asking.
Yes, sorry.
She says it explicitly in 30, the relationship with the council was a business connection.
Yes, that's right, sorry. Is it tab?
Five.
Okay, look.
I mean, some idea along these lines sort of makes some sense. I mean, if you have a newsagent partnership which is dissolved, before the dissolution, the partners were buying Kit Kats from Nestle
Yes,
and the Times from the Times. It would be really odd if
yes,
post-dissolution those counted as business connections for the purposes of Section 29,
Yeah.
because anybody can buy
exactly.
Kit Kats from Nestle.
Yeah.
And
Yeah. Yeah.
if, on the other hand, you have some exclusive arrangement, it feels different.
Yes, exactly. And well, you know, our submissions, it wasn't exclusive. Just going.
Well, the judge may have been right to this extent. It's always going to be a question of fact and degree. What's missing for me in his judgment is the question you're trying to answer
Yes. Yes. Yeah.
by applying fact and degree.
Yes.
So, I mean, that's what I think at the moment I'm still searching for.
Well, my submission is that
I mean, you just need to say, whatever it means, this isn't it.
exactly, and that's what we did say. But I don't know.
What, as put to the judge,
Yeah.
I think you said you broadly stand by that.
We-
He recites the submission you made.
Yes, I mean, I think that what we probably didn't, I think it was implicit in what we were saying, but what we didn't say, look, this is a business that's only run for 7 months. It, you know, a business connection, if a partnership is going to have a business connection with a third party, you have to be able to demonstrate that there is so much loyalty coming from the business connection, ACON, that, you know, that they will want to use you come what may. And A, how can one possibly demonstrate that in 7 months? And B, on the facts of this case, that just wasn't there because of the fact that they were.
You're sort of saying it's inherent in the concept of something that belongs to the
Yes,
partnership.
that's what we would. Yeah.
You know, in the same way as property or name, that there has to be something other than a merely transitory.
Yes, and it have to be something other than the fact that the partnership itself used ACON exclusively. That means nothing.
I'm not quite sure who this would help actually, but going back to the idea of goodwill, could it be the sort of thing that somebody might pay for? I mean,
You know, against myself, I'd love to be able to say that, but against myself, I suspect not, in the sense that when one looks, it's accepted that goodwill, although it often can be something that you can protect, you know, it also goes beyond that. And for example,
But people do pay. I mean, if it was paid for in Perkins and Shaw, even though it
yes,
was
they
found,
do.
People do pay.
Yeah, they do.
Um,
Yes, they do.
that there's something that you can't grasp
Yeah.
or,
Yes.
or legally enforce, if you like.
Yeah, it was certainly nothing that
It's value and
Yeah.
it's
was
an
a-
expectation.
it was certainly nothing that could be sold
Yes.
at dissolution. I mean,
I mean, the curiosity as well, I think, is that it's very easy to talk in terms of buying goodwill, or acquiring goodwill if you're acquiring a company
Yes.
which has goodwill,
yeah,
because in a sense the corporate entity continues and you buy the
Yes.
shares in it. It's much more difficult, to, I suspect, to contemplate paying money for goodwill where it's a two-person partnership, because by definition you're trying to buy something
it's
which
going to cease.
is going to cease and is inherently personal to
Yeah.
two identifiable individuals.
And the supplier or customer will know that they're dealing with a
Yes.
different
Yes.
entity.
Yes,
You know,
Yeah.
'cause I mean,
yeah,
to take my lord's example, I mean, I dare say WH Smith has significant customer goodwill because
Yeah.
customers, see
Yeah.
the name,
yes, exactly.
assuming WH Smith is a
Yeah.
company, I don't know, I just picked it out. Other newsagents are available.
Yeah,
But
yeah,
that's a more easily identifiable form of goodwill. But the fact that WH Smith buys its Times newspapers from the Times,
yes,
unless there's some sort of supply contract, I'd be surprised if you pay anything for that, because you can just set up your own
Yeah.
of the Times and other newspapers.
and on that, I mean, bearing in mind that a name is normally associated with goodwill, and Section 29 does talk about the name, as well as
But that's because a partnership may be carrying on business under a
The-
particular
mm,
style.
yes,
name.
yes, exactly. But it would normally
It's not
typically be
personable. It's going back to the point my lord I think was making. It's not personal to the two individuals.
no, but it would be ordinarily treated as part of the goodwill. So you've got a sort of overlap if business connection includes goodwill. I would be just about content to say that business connection can be more than goodwill, but for that I go back to the analysis that I developed yesterday, that if that is going to be something for which a partner needs to account post dissolution, then it needs to be seen in much the same way as the grafting on of renewal contracts. So you would have a contract between a supplier and the partnership, or a customer and the partnership, which is in existence as at the date of dissolution.
Can I generalise that
Yes,
a bit?
yes.
I mean, ordinary fiduciary law says maturing business opportunity
Yes,
can give rise to duties.
yes,
And now we don't know whether a maturing business opportunity was seen as property in 1890.
No,
I don't
no.
suppose it was. It was probably seen as
yes,
connection.
yeah,
So connection on this thesis would encompass at least maturing business opportunities.
I think it would, although the judge was unhappy with the fact that both sides had actually initially focused on maturing business opportunity. I mean, we had a disclosure application which was all about whether what we had to give disclosure of, and the argument against us was that the Danish deal was a maturing business opportunity, but the judge held that it wasn't. And one of our arguments, which he accepted in a sense, we were arguing that there couldn't be any breach of fiduciary duty by Mr. Hughes, particularly in relation to the Danish deal, because that really, I mean, the other sales were just de minimis really. We were saying, well, how could he be liable? Because it wasn't a maturing business opportunity, which the judge agreed with us on, but then found that Acon was a business connection. And when you look at that paragraph, when he's talking about why Acon, he finds that Acon is a business connection, part of it is focusing on what he felt Acon's position was. But of course, you do have to look at it from the partnership's position and the extent to which the partnership can attract loyalty from a customer or a supplier, resulting in, a willingness by the supplier or the customer over a long period of time, if one looks at the margarine case, to supply that distributor or the distributor to supply that customer over a long period of time, and we would say exclusively, because otherwise, on what possible basis can you say that you've built up that kind of loyalty to the particular business? I wonder what we could. We have got some references to textbooks and things where, and also the Law Commission. But rather than sort of go on about that now, perhaps we could provide a note overnight and hand it up, because the extracts tend to say, actually all say, is that the approach to business connection, such as it is, has all been in connection with customers as opposed to suppliers.
Doubt to say, but you accept that there could be supplier.
Analytically,
Yes.
I can't really see a major difference. I think the difference is that you have to have an established business and you have to be able to demonstrate that your relationship with the third party demonstrates
I mean, to pick up my Lord's example, suppose a company had an exclusive deal to buy a unique product with a supplier.
Mm-hmm.
It's very easy to see that the
Yes.
purchaser of the company would pay for that.
Yes, exactly. And of course,
Well, it's easy to see that, play tag on this if we may, it's easy to see that that might be something that both ranks as property if protected by some enforceable contract and a business connection.
mm-hmm,
It's
yes.
much more difficult, I think, to see the business connection of the partnership if it's simply the fact that a partnership consisting of a limited number of people have become, even for a short period of time, able to buy something from a supplier.
Yeah.
But that is the partnership that's going to be dissolved.
Yes.
I mean,
Yeah.
it's quite difficult to see. You know, you need something, I think, a bit more specific about the action. I mean, I'm just trying to understand what the judge, was grasping for when he said it's fact and degree, and I can understand. I have some sympathy with the judge sort of not being able to nail down a definition, especially if, as you said, this was not really the subject of any, great debate or indeed fact finding. In the way that we've been looking at it now. Anyway.
So I've lost my place. So I'm. So, to conclude our submissions on this aspect, and it's really grounds 1B and 1C, we say that the finding that ACOM was a business connection is unsafe, and I've already submitted to you that what we say is that business connection means the partnerships, relationships with a third party in the nature of belonging to the partnership, viewed from the point of view of the partnership, so that the partnership can actually say that because of the loyalty, because of the business that we've built up with this particular entity, we can say that we've developed something of value in the sense of goodwill. and we accept that, as I've submitted to you, that in principle a partnership's relationship with a manufacturer or a supplier could be a business connection, but we say that ACON was not a business connection on the facts. Whether you say that
It's not a business connection on the fact. I mean, just to be clear about this, I mean, the judge seemed to think that whether something is a business connection is a question of fact.
yes, well, I don't think you. Well, in my submission, that's not right. One has to work out first what a business connection is as a matter of law, and I accept that it's a somewhat elastic concept. But if you're looking at what the Partnership Act is trying to prevent, you know, the breach of fiduciary duties that the partnership is designed to prevent. Finding that ACON, in this case, is a business connection is not something in my submission that Section 29 was designed to present as, you know, a 7-month-old business that's been buying tests from ACON for 7 months is not the type of business connection that's you know that Section 29 was aiming at. It
I
has
have just one question on that. Section 29, of course, primarily applies while a partnership is ongoing.
yes.
It's only Section 29(2) that
Mm.
tells us it applies on dissolution. Might it be the case, particularly when you read the provision in the context of the other provisions of the Act which deal with dissolution, that maybe Section 29 has to be applied in some form of modified way post-dissolution? Because if you are, you know, for example, what if the
Yes.
Danish deal had come along
Mm.
while the partnership was still
Yes.
trading? The answer you might accept might be
We-
different from what you're submitting now.
My lady, we thought about that, and we thought that quite possibly that in those circumstances it would be Section 30 that would be more apposite, because Section 30 prohibits partners from competing against the partnership.
Well, and maybe that's one part of the
Yes,
context
but I
in
can
which
see,
you've
yes,
got
I
to
can
read
see that
29.
there's potentially an overlap, but I'd endorse what you say, that, and I suppose that's where Section 38 clips in. I'd endorse what you say, that and it was accepted on both sides that the duties shift from during the partnership to post dissolution. That was accepted, and yet really what Mr. Manduka is trying to do is trying to get an account from Mr. Hughes of the type that he would be expected, he would be entitled to require if Mr. Hughes had gone off and started buying tests from ACON clandestinely during the currency of the partnership.
Well,
Sorry, go on.
Yeah.
This might be another way of approaching
Yes,
this
yes.
conundrum.
Yeah.
The difficulty we're having with Section 29
Yes.
is
Yeah.
is potentially one that is specific to a dissolution scenario.
Yes, it is. Well, and that's why, I mean, there are very few cases that I've drawn them all to your attention, which have addressed this issue of post-dissolution profits. All I can say is that I made my submissions yesterday as about how they all differ from what happened here. It's rare on any view, and this case doesn't come anywhere near it.
And just to extend my red herring of a little while ago, I referred to paragraph 10.430 of Lindley.
Yes,
There's a
sorry,
footnote
we've got
to-
a note of it. Yes,
There's a footnote to that, footnote 1292, which is in this sort of territory. So I don't suggest anybody looks at it now.
no, but we will add it to our list of references in relation to customers. So, ground 1D I can deal with quite quickly. Ground 1D goes to the judge finding that purchasing and sale of unbranded, as they were called, NFTs, they really were branded. They were Acon's own brand called Flowflex test post-dissolution, also involved a contravention of Section 29. The point is material because the tests that were sold to the Danish government, some 8 million were Hughes healthcare tests, which, as the judge found, the Danish government only took because they were persuaded that they were identical to the Flowflex brand, and they were needed urgently, and therefore there was some Hughes healthcare tests lying around that Mr. Hughes was able to fulfil the first contract with. And then 35 million were Flowflex tests, and they were delivered in subsequent contracts, orders with the Danish government. And if one goes to paragraph 396 of the judgment, that's core bundle page 165. He says that the Hughes healthcare branding was not a factor that pointed in favour of the Danish government placing an order with MSDL. The Danish government was sold on purchasing Flowflex tests. Accordingly, the Hughes healthcare branding on 8 million of the tests that the Danish government purchased was an obstacle in the sense that Mr. Butcher had to spend time and effort to satisfy Jacob Prange of the Danish government that the branded tests were identical in all respects other than their packaging to Flowflex tests. That's the background, but the finding was effectively that there was Mr. Hughes had to account both for the sale of the Hughes healthcare branded tests and the Flowflex tests. Now, I've already referred you to the case of Assen Benham and Dina McDowell, to the effect that a partner isn't liable to account for profits outside the scope of a partnership's business. And in O'Donnell and Shanahan, which concerned a unfair prejudice petition in connection with a quasi-partnership, that's at tab 42 of the bundle. That case is of interest just because it...
Meaning we should look at it or not?
Well, I can tell you...
Yes.
I think, so Lord Justice Reimer at paragraph 68 of the judgment pointed out, relying on citations from Boardman and Phipps that he'd referred to earlier in the judgment, that unlike trustees and directors, the duties of partners are limited by the terms of the partnership agreement. And that's something that I rely on. Whereas he went on to say that the duties of trustees and directors are not similarly circumscribed. The duties of a director are unlimited and akin to a general trusteeship. And this case I do want you to look at, consistently with Lord Justice Reimer's comments that the duties of partners are limited by the terms of the partnership agreement. Miles and Clark, that's at tab 21 of the bundle, that was a decision of Miss Justice Harman, and it was a...
I'm sure I'm told by that, just out of interest. I mean, all fiduciary duties are capable of being modified by contract.
Yes.
I mean,
Yes, I suppose even the directors, yes, absolutely. But I think he was saying, look, absent an agreement, then they're unlimited. But with a partnership, you've always got a partnership agreement.
well, I mean,
I suppose even with a trusteeship and directorship, you might have an agreement. Yeah.
conventionally,
Yes.
conventionally, you ask the question, "What are the duties?"
Yes.
Set
And
out
you
in
look
the
at-
office and the
yes.
and is the result a fiduciary relationship? You don't do it the other way around.
No.
Anyway, there we go.
Yeah, but he did say that, didn't he? So Miles and Clark is a decision, Mr. Justice Harman, where the plaintiff and the defendant were partners at will, so like this case, and they conducted a business as commercial and fashion photographers. And the plaintiff was a well-known photographer, and he brought in considerable goodwill with customers. and then the leasehold premises, furniture and studio equipment belong to the defendant. And the latter also claimed to have contributed to the goodwill of the business. Both parties brought in a quantity of negatives, and it was intended that a partnership agreement should be drawn up, but it never was. On taking an account on the dissolution of the partnership, it was held that no terms ought to be implied except such as were essential to business efficacy, and that only the consumable items, stock in trade, which were in fact used, were to be included in the assets of the partnership. The ratio of the judgment,
I think there's
it's
a
page
really
307.
far more important observation about accountants at the bottom of page
Yeah.
539.
So,
Funny enough, I'd seen it.
sorry, 130.
Sorry, if you look, sorry, it's complete.
All right.
This Justice Harman said the defendant employed an accountant. Accountants are the witch doctors
Oh,
of
right.
the modern world.
Yes,
And
well,
they too are apt to deal with unrealities, and the accountant is tries to produce extraordinary results, etc.
No,
etc. Sorry, that was just a bit of light.
Where, that's not the ratio.
Yeah,
Where
No,
is
it's not the
where
ratio,
is
although I will remember that.
yeah. Yes, I am as well.
Really grateful. This is the best case we've had so far this year.
So,
Sorry, those are accountants. I apologise.
well, I think that was his view generally, wasn't it? Miles and Clark has been cited recently. You don't need to turn it up in Wild and Wild, tab 51, and a case called Malik and Hussein at tab 53. But the issue in each of those cases was what constitute partnership property. And so what we say is the principle is the general one, and in each case you look at the agreement to determine what the agreement was as to the scope of the partnership business. Now, as found by the judge, the partnership agreement between Mr. Manduka and Mr. Hughes was the buying and selling of Hughes Healthcare branded tests. This is clear from paragraph 56 of the judgment, which is the core bundle, page 97. Acon had its own branding, Flowflex, that it used to sell its LFTs, unbranded tests, on the basis that they did not bear the brand of the partnership. However, Acon was also prepared to supply tests of the partnership that bore the partnership's Hughes Healthcare branding on its packaging and other materials. Since the partnership was interested in promoting its own brand, its orders with Acon tended to be for branded tests. This was a position that was accepted by both parties, that what they were interested in is promoting their own branded tests. If one looks at the page 222.
Just before you do, when it says tended to be, that means
Well, there is one, I think where the judge got that is the one example that my learned friends have come up with, where there was an order for 50,000 tests from Newfoundland. But my point about that is that that's the exception that proves the rule. Except that one example that my learned friends have come up with, all the tests that were ordered were for branded tests. And I suspect that, the reason why I think the judge included, because it wasn't an argument that we raised with the judge post the judgment, I think it was, is that because there was no difference between the two in the sense that they were the same test, he felt that he should lump them all together. But our argument was, well, no, that wasn't what the partnership was set up to do. The partnership was set up to develop and sell its own test. They persuaded Acon to package up the Flowflex test as a Hughes Healthcare test. And they were even, towards the end of the partnership, developing their own test called the Hughes Veritas test. It was.
Hasn't the judge made a finding of fact? Well, not just there, but he later rejects your argument about the scope of the business, doesn't he? And says it's just tests, whether branded.
Well, yes,
is that not a finding of fact?
Well, no, in my submission, it's a misconstruction of the agreement between the parties. I mean, he found that that we were selling, but it's a misconstruction of the agreement between the parties, because where my learned friends can only come up with one example where an order for Flowflex tests was placed by Newfoundland with us. As I say, that doesn't demonstrate that the partnership's business was the sale of LFTs generally.
So,
Well,
I mean,
COVID LFTs
suppose for the sake of argument, they said, well, actually, we don't think Hughes Healthcare is marvellous after all. We think Hughes tests should be used. Would that be a different partnership?
No, but it wouldn't be a different partnership. But the partnership agreement would have changed so that they're now selling Hughes tests and not selling Hughes Healthcare tests.
So that would involve a variation of the partnership
Exactly, and there's
agreement.
no evidence that Mr. Manduka and Mr. Hughes ever varied their agreement to sell Flowflex tests in addition to Hughes Healthcare tests. Sorry, I should have made that point clear. And so in that regard, the judge misdirected himself, because in order to find, as a matter of fact, that the partnership was selling, was in the business of selling Flowflex tests, he would have had to have found that there was a variation of the agreement to do that. And there is no evidence that that was ever done. And as I was just taking you to the pleadings, the core bundle 222, there is a plea at paragraph 12 of the amended particulars of claim saying, for example, they developed Hughes Healthcare branded tests, the boxes for which were designed and initially produced by Mr. Hodnett and Freddie Manduka, and we admitted this at paragraph 108, subparagraph D of our defence at page 302, core bundle 302. And there is no plea anywhere in the pleadings whereby it is pleaded that the partners subsequently agreed to market, purchase and sell Flowflex tests. So I think it's a short point. I can now move on to ground 1E. Ground 1E concerns our argument based on fiduciary reciprocity, to the effect that we say that the judge erred in law in holding that a partner is, in effect, strictly liable under section 29 for post-dissolution profits, regardless of the conduct of the other partner during the subsistence of the partnership. And now I accept that, that this argument isn't, to my knowledge, run, certainly in modern times, but the obvious reason for that is that most of the time, invariably, it's very unusual for a partner who was himself in serious breach of fiduciary duty to come to court and say, well, but I want my co-partner who didn't commit a breach of fiduciary duty during while the partnership existed, but I want him to account for post-dissolution, all the post-dissolution profits that he made after he terminated the partnership because he didn't trust me any longer. So I think that's why it doesn't appear very often.
At the risk of just, can I just try and get straight in my own mind the target you're going to be aiming your submissions at in structural terms? Do you say that if you have two partners and one of them commits a breach of fiduciary duty by making a secret profit, unknown to the other partner,
Yes.
that there is a change in the nature of that other partner's fiduciary duties to the partnership?
Well, there's two ways of
and if so, when?
Yeah.
How does that manifest itself? Or are you simply saying that somebody who has acted in breach of fiduciary
Yeah.
duty cannot come to the court and claim some sort of equitable.
Yes, there's
Which, because those are two very different things.
well,
I
I'm
just wanna get
saying
it
in
clear.
two different ways. I'm saying it in two different ways.
Well, no, those are two different things.
Yes, they are. I accept they are. But if you could just let me develop the argument, and then you can
Right.
say no, you can't say that. That's wrong. If that's all right. So we ran the reciprocity argument. It's set out at paragraph 261 of the core bundle and paragraphs 265 to 269. And the judge held that Mr. Hughes' liability to account under section 29 was not conditional on whether he owed any fiduciary duties to Mr. Manduka, so that even if Mr. Hughes was correct and that Mr. Manduka's breaches of his fiduciary obligations released Mr. Hughes from his own duties, any liability to account imposed by section 29 would not be affected. And then he went on to hold at paragraph 267 that the obligation to account under section 29 is not conditional on any species of good faith obligation or indeed any other fiduciary obligation being present at any particular point in time, and concluded that even if Mr. Hughes is correct that he owed no good faith obligation to Mr. Manduka after the dissolution email, the statutory obligation to account under section 29 would remain. And at 268, there is no policy reason to support such an approach or to displace the usual rule to the effect that anyone who commits a breach of fiduciary obligations should be answerable for the consequences. And what we say is that obviously the judge didn't attach any weight to the argument on reciprocity. He just said, you know, section 29 applies. His position was effectively that whether the breach is known about or not, even if the breach was known about, and of course the diversions were known about, and other breaches as well, but even if the breach is known about, it doesn't switch off the other partner's fiduciary duty. And we say that's wrong, that has to be wrong. The idea that a partner breaches his fiduciary duty in a serious way towards his partner, the idea that the co-partner has to continually loyally serve that partner's interests, that breaching partner's interests, it just cannot be right. I mean, I can't, it just does not make sense.
Okay, so
Yeah.
does this depend upon the innocent partner in your example knowing what's going
Well,
on?
first of all, the innocent partner did know about the diversions.
As a matter
But
of course.
yes, I do. I don't think it necessarily. I don't think it does require the innocent partner to know. There are different ways of putting it, as you rightly say. One way is that the court says, no, I'm just not going to give relief to this partner who breached his fiduciary duty in such a serious way that I'm just not going to give any relief to that. But the other way is to say that, and that doesn't depend on whether the innocent partner knew or not. It depends on the exercise of the court's discretion, equitable discretion. The other way is to say, well, even if I don't proceed along that route, the fact that the partner didn't know about the breach doesn't mean that the court can't hold that objectively, from the point at least where he dissolved the partnership, he was no longer under a fiduciary duty because he couldn't. Because if the court doesn't decide it in that way, it means that a partner who is not clever enough to hide his secret profit, and the partner finds out about it before he goes off post-dissolution and makes post-dissolution profits, doesn't have to account because he found out about it, and so he says, well, no, I'm no longer under the fiduciary duty. But the partner who has been subject to a far more secretive and mendacious conduct by the partner who made a secret profit and doesn't find out about it for months afterwards, he's in a worse position. Again, that can't be right.
Can I sort of talk around it a moment? So here the secret profit starts at the beginning of the year. I can't remember, roughly.
In January, yeah.
You say, well, it doesn't matter whether Mr. Hughes knew about it or not.
Yeah.
Did Mr. Manduka have any rights from that point onwards in the partnership?
Well, that's what I was trying to say, that it was really, he was really in a partnership that in name only from that point. That's why I was sort of, I know
so
you
to
did.
be clear, he had no right to any partnership share from the beginning of 2021. If the partnership made a profit, he was not entitled to any of it.
No, I think that until Mr. Hughes dissolved the partnership continued, and therefore, I mean, it's a bit like the repudiatory breach analysis, but we're not relying on that. Although I'm not saying that couldn't apply, but until Mr. Hughes terminated the partnership, then the duties between them continued. But at the point,
That's my sort of
yes,
instinctive reaction to this label of a partnership in name
only,
only, I'm
yes,
afraid.
yeah.
So, I mean, there's another example of essentially drawing a distinction potentially in the application of Section 29.
Yes.
In the position before dissolution.
Yes,
and
you're
the
right,
position
Mandy.
on dissolution, at least if that dissolution is in some sort of, for some sort of reason connected with misconduct.
Yes.
On your submission,
Yes.
I'm not saying this is right.
No, I accept.
understand it.
Yeah. So, if I can just take you very quickly through the case law, which I accept is a bit bitty, but it does support the idea that the court can either deny relief or can effectively find that from a particular point the fiduciary duties no longer on the side of the innocent partner no longer applied.
Those are two, sorry, I'll repeat.
Yes, they are.
They're two very different things, because
They are.
one is the court is saying there are fiduciary duties and an existing partnership, and fiduciary duties going in both directions, but when the court then takes an account, either in equity or under Section 29, it might give a direction that certain things are not to be brought into the account.
Mm-hmm.
But that's quite different from something which says that the duties just don't apply at
Yes.
all.
No, I see that. I do see that. Well, and the texts and the cases aren't, they don't talk all in one voice. One thing, obviously, we always need to bear in mind is, unlike the other fiduciaries that I mentioned at the outset, this is, the relationship is supposed to be reciprocal, and if one party isn't reciprocating, that I say there needs to be that the innocent party nedes to be relieved, because otherwise it's just
It can be relieved through the taking of the account.
well, but yes, but at the moment where we are on the judgment says no, the obligation to account remains under Section 29, and it's irrelevant. It's irrelevant even if we're right and the fiduciary duty can be switched off, or even if we're right and Mr. Hughes no longer owed any fiduciary duty post dissolution. So in effect, we've got a finding along those lines, which when we get to the account, will follow through into the account. I don't see how, with that finding, it would be open to us to run the argument again that we ran before the judge, which failed.
Yeah.
So, so, as I said, the learning on the topic doesn't always maintain a clear distinction. We have Linley and Banks which is at tab 106, page 2409. Paragraph 1612, where it said that the duty is a reciprocal one. Thus, if one partner chooses, in the words of Lord Linley, to repudiate the contract of partnership and refuses to perform his duty towards his co-partners, he cannot complain if they adopt a similar attitude towards him. And then, as observed by Lord Eldon in Constant Harris, a partner who complains that the other partners do not do their duty towards him, and that's obviously Mr. Manduka, must be ready at all times and offer himself to do his duty towards them. Our point is that Mr. Manduka didn't. And going back to the first paragraph, if he refuses to perform his duty towards his co-partners, that's Mr. Manduka can't complain if they adopt a similar attitude towards him. Now, just as an aside, Constant Harris, I don't know whether your lordships are aware of it, but it's a sort of bit of an odd case because Lord Eldon comes out with these pronouncements, but actually the case was not really about breaches of fiduciary duty, and it was all about whether an original partnership agreement could be varied or amended in the context of one partner not having been consulted or agreed on the amendment. But he does come out, he clearly wants to, Lord Eldon clearly wants to say something about the nature of partnership generally. This reciprocal nature of the duty can be traced at least as far back as the first edition of Lord Linley's A Treaty on Partnership. I'm not going to take you to it, but that's at tab 80, where he talks about notwithstanding the universal application to partners of the rule requiring the most perfect good faith, if one partner repudiated the contract of partnership and will not perform his duty towards his co-partners, he cannot justly complain if they in return decline to treat him on a footing of equality with themselves. And that seems to be an echo of that first edition of Constant Harris, which was decided in 1824. The respondent's response to this part of our skeleton is at paragraph 91 of their amended skeleton, and what they say, they repeat the judge's view that section 29 is not conditional on any species of good faith obligation or any other fiduciary obligation. We've already explained that this is wrong. I mean, you've got Lord Linley, Lord Eldon talking about the relationship being mutual and reciprocal. And so to say that section 29 isn't conditional on any species of good faith obligation or other fiduciary obligation, it just simply, doesn't make sense. And then at paragraph 92, the respondents accuse us of relying on a partial quotation of Linley and Banks. And at paragraph 93, they contend that Linley and Banks affirms the position that an innocent partner remains bound by his obligations. But we don't accept that position. Firstly, we say that obviously the reliance on the quotation isn't misleading in any way. The subsequent passage, one goes to tab 80 in the bundle, at page 2248. It refers to the quote of Lord Eldon in Constant Harris, which was at paragraph 524 of the Constant Harris judgment.
So, have I got the wrong thing?
Yeah, I think in the respondent skeleton, they're referring to a misleading quote from the current edition of Newey and Banks.
Oh, right. Well, I can.
Well, that's what the skeleton says, which is the passage you took us to earlier.
I think.
Hence the citation of a case in the 21st century.
So, sorry, my mistake. I think we. So I think if you look at our supplemental skeleton, I think we. Is it 72 of the core bundle? Yes, you're right.
Sorry,
So-
72.
Of the core bundle.
Oh, I see.
So
It's the
it's-
supplemental
it's-
skeleton.
it's-
Yes,
it's-
yes. Sorry, yes. Naturally, I've cannibalised it.
So let's go to 16. And maybe the answer is to turn up.
I mean, this is.
You're not interested.
I'm not sure it's worth spending a lot of time on this because we're
Right.
interested in what the law is,
Okay.
not whether or not
All
a
right, then.
particular quotation has been
Right,
accurately
okay.
recorded or not.
Very well. I'll go on because our main point is that what both Constant Harris said and what Linley says is that that a partner has no cause to complain about a partner's conduct if that partner has failed to discharge his duty to his co-partner. There is a subsequent statement in Linley. And one can see that. Hold on.
The trouble with all these sort of dicta,
They're a bit bitty.
well, not only are they bitty, but they aren't descending to the analysis. They're just a generalised. Well, you can't complain. You know, it's
Yes.
tit for tat. It's you must do right by the other party. I mean, none of those are legal concepts. I mean, there are two legal concepts at play here, and I keep coming back to it. One is that the duties change, and if so, I'd like to know when, how. And then the second proposition is that duties don't change, but the method of taking
Yes.
an account may differ depending upon the conduct of the two parties. And you know,
Well,
speak for myself, I'd quite like to sort of know whether anybody has actually analysed the problem in the way described.
well,
And if so,
yeah. Well, maybe we look at some of the earlier cases, which I mean, they get some of the way there. Of course, they're not expressed in quite the same language as we would express them today, but they certainly do indicate that the two possibilities that we're talking about. So, Malure and Ripley is a case that is cited both by Linley and Blackett Ord. That was decided in 1850. It's at tab 12 of the bundle. This was this was a case where sorry, I've got the wrong Yeah, this was a case where two partners entered into a joint venture for the purchase of goods to be shipped to China, to be there sold, and the proceeds of the sale invested in a homeward cargo. The first partner was to render himself liable for the payment of the goods purchased, and then the other partner was to supply the partner with the share of the money 5 years' time, and the other partner didn't. He just refused to do so because he took a different view as to the success of the venture. And so
They were partners, weren't they?
they were partners, yes.
Does it say that?
Yes,
It does on bottom of page 88,
thank you, my lady.
halfway down, they've engaged for partnership.
Yeah.
The group jointly interested.
Yes. So so what happened is that when the partner said, "I'm not going to pay," because he'd taken a different view of the success of the venture, the other partner said, "Well, okay, you can withdraw from the adventure altogether," and that offer was accepted. But down to the time when the money was applied for to the partner who refused to pay it, the other partner had communicated all the information to him, but then after the partner said, "I'm not going to pay," information came to the other partner to the effect that actually the venture was going to be quite successful after all. And the partner that refused to pay subsequently brought a claim for his share of the successful venture. And the court held that he wasn't entitled to because Malure, that was the name of the partner, ceased any longer to have the rights of the partner after he failed to perform his part of the partnership contract. Now, my learned friends seek to distinguish Malure and Ripley on the ground that Malure was refusing to perform and that as a consequence Ripley had a right not to treat him as a partner. But the same can be said in this case. As I said in opening, because of Mr. Manduka's breaches, the partnership really was all one way at least. The breadth and the seriousness of the breaches by Mr. Manduka were demonstrative by him of a deliberate decision by him not to perform his obligations of good faith from the outset. And therefore, post-dissolution, Mr. Hughes had a right not to treat him any longer as a partner. Now, another case is a decision of the Manitoba Court of Appeal, which followed Malure and Ripley. And that case is at tab 75. The relevant paragraphs are at 24 to 27. That case again held that one partner, having two partners, were not obliged to share information relevant to the sale of a partnership asset.
Sorry, can you give me the...
Yes, it's at tab 75, and the relevant paragraphs of the judgment are at paragraphs 24 to 27. So that was a case where one partner was held not obliged to share information relevant to the sale of a partnership asset, some land, and to account for any consequent profits after the other partners failed to honour their obligations within the partnership to pay one half of a required mortgage payment. This was because, as the Court of Appeal said at paragraph 23, the partner's obligation of full disclosure had come to an end. That obligation, based on the concept of perfect good faith among partners, does not survive the repudiation of a partner's obligations. Now, the respondents at paragraph 98, subparagraph 3 of their amended skeleton seek to distinguish the outcome of Ackman and Chipman on the grounds that by refusing to pay the mortgage payment, the Ackmans had signalled that they no longer wish to be partners with the Chipman and Al, who were the other partners. But looking at Mr. Manduka's conduct objectively, Mr. Manduka renounced his rights as a partner almost from the outset. So similarly to Ackman and Chipman, an individual can't claim to be a partner on the one hand and on the other hand repeatedly behave in a way that is entirely inconsistent with being a partner. And Chapman and Ackman and Chipman is an example of that. Now, we were criticised for citing Davy and Davy, which is a summary judgment application before a master. But again, the facts in that case showed that's
Can we really hope to get anything out of a decision
well,
that
only
something's arguable?
Yes, yes, that's true. She does say it's arguable, but why I say that it's well, I draw it to the court's attention. Of course, judgments of masters are not binding on the court, but it is cited as an example of a High Court master supporting our case that Mr. Hughes was not required to act in good faith towards Mr. Manduka and not to continue to loyally serve him when Mr. Manduka was not acting in good faith to him. And the fact that that principal appeal to Master Clark is consistent with, we say, the reciprocity duty.
You have to loyally serve. Is it the partnership or the partner?
Well, the partnership is not a separate entity, so it must be the partner.
No, I know it's not a separate entity, but the whole concept of a partnership is that there is a partnership of business.
Yes. Well, my lord, I'm not saying, for example, that Mr. Hughes wouldn't have had to have paid off the debts of the partnership, which he in fact did. There are still debts that Mr. Manduka hasn't contributed to, not much, it's fair to say, but about £200,000, maybe a bit more. So I'm not saying that Mr. Hughes would be released from those partnership responsibilities by reason of Mr. Manduka's breach of fiduciary duty. And I'm not saying that Mr. Hughes, if there was partnership property, you know, leases of premises and so forth, that he and the lease was in his name, for example, that he, but it was partnership property, that he wouldn't have to account for 50% of the proceeds of sale on the basis that that was all acquired pre-dissolution. What I'm saying is that post-dissolution, when he'd effectively accepted and knew about Mr. Manduka's breaches of fiduciary duty, alternatively accepted that the relationship could no longer go on, that from that point he was released from any further obligation to account to Mr. Manduka.
I mean, at that stage, in any event, under Section 38, you're only supposed to be winding the partnership up.
Yes.
If you're engaged in winding the partnership up, realising pre-existing assets, which, as you say, would have to be shared between the partners, why are your duties further whittled away?
Well, only because from the date of dissolution, Mr. Hughes was starting a new business. He wasn't, we would say, using assets that were otherwise attributable to the partnership pre-dissolution. And even if he was, although he might have to give account for the assets that were actually known as assets, so, you know, a lease or something like that, there is a distinction between making profits from an asset and being required to account for the asset. In effect, if he didn't, as we say, owe any further fiduciary duties post-dissolution, he might be required to pay, supposing he used premises, he might be required to pay for the use of the premises, but he wouldn't be required to account on a fiduciary basis from the profits that he made from the use of the premises.
And just to understand again, suppose that before the dissolution, the Danish deal had been underway, making
Yes,
a great deal of money,
yes,
and Mr. Manduka had, admittedly entirely improperly, diverted one small order to his son's company.
yes. No, the breach of fiduciary duty has to be serious. I'm not saying it's any breach.
Well, it must be quite serious still. I mean, it would be a...
One small order.
Okay.
No, no. I think he can be forgiven for one small order, but it has to be a serious breach of fiduciary and an ongoing one. I mean, you know, the courts are well able to determine, you know, to distinguish between serious breaches and not serious.
Well, the Lord's question does point up. I mean, you say, okay, laughingly, one small order, but let's say it was one small order, but procured. So I'm just going to talk about now A and B. Okay?
Yeah.
I'm not talking about the facts of this
Yeah.
case. Let's just say there are two partners, and one of them commits, you know, a thoroughly dishonest breach of fiduciary duty, but only of small monetary amount, not known to his other partner.
Yes. Mm-hmm.
Your consequence is that unknown, the other partner is what unknowingly either released or not released from his fiduciary duties, depending upon who takes the view as to whether it's enough.
Yeah. Well,
Yeah, I mean, this is why I'm struggling with this whole concept of fiduciary duties being altered as things go along, as opposed to a court subsequently saying, well, now we know the facts, we can adjust the account.
But I see. Well, I'm going to get on to that. I see that's another, and the cases do go down that route. But I do. I mean, if one, and I know that in Hurst and Brick, Lord Justice Morritt said that in the context of an argument about you can't dissolve a partnership on the basis of repudiatory breach, you know, you can't, that you have to use the mechanisms provided for by the Partnership Act. But he didn't exclude entirely the operation of repudiatory breach on the partnership contract. And just as not all breaches are repudiatory, not all breaches of fiduciary duty are, you know, and the textbooks and cases do use the word repudiatory, are repudiatory. But where you have a serious breach of fiduciary duty, then I say the court can, just as one in the context of the doctrine of repudiatory breach in contract, the court can say right from, and I think it would have to be demonstrated, and what we say is that the dissolution email does demonstrate it, that from a particular point, the partner accepted that the breach was repudiatory and brought the partnership relationship to an end.
Can I just pursue a moment?
Yes.
So you've explained that, on your case, Mr. Manduka didn't lose all his rights at once when
No.
he entered into the secret arrangement.
Mm.
So up to the dissolution, he continued to be entitled to profit share.
Yeah.
Now, at the point of dissolution, there is a well-advanced, maturing business opportunity.
Yes.
Suppose.
Yes.
Mr. Hughes, for different reasons, dissolves the partnership and pursues, hypothetically,
Yes.
the well-advanced, maturing
Yeah.
business opportunity.
Yes.
Does Mr. Manduka have any rights in respect to that?
If it was I'm being told by I didn't know, but if it was a maturing business opportunity at the date pre-dissolution, I think he would have had rights. It's the analysis I'm trying to draw is using the doctrine of repudiatory breach, because once the repudiation is accepted, all bets are off, all future liabilities are extinguished, but the partners are still, not partners, but the contracting parties are still liable for pre-termination matters, liabilities. And there is nothing in the judgment of Hurst and Brick that, and in fact, Lord Justice Morris actually acknowledges that.
It is Lord Millett, isn't it, I think?
Oh yes, Lord Millett. I do sorry. Yes, it was Lord Justice Morris in Don King. Yes, Lord Millett acknowledges that that repudiatory breach can apply to the partnership contract. What Hurst and Brick was all about is you can't dissolve a partnership. You know, you can't say, right, the partnership's dissolved because the obligations have repudiated and I accept it. You have to dissolve a partnership in the ways in which the partnership provides for. That is what Mr. Hughes did. But we also say that obviously, I mean, looking at it objectively, when Mr. Hughes served that dissolution email, it should be treated also as his acceptance of the repudiation by Mr. Manduka of his partnership obligations. The page in Hurst and Brick is at tab 31, and the PDF page where Lord Millett identified the question that he was considering, which was not whether the doctrine applies to the contract of partnership, but whether it operates to bring about the automatic dissolution of the partnership relationship. And that's at internal page 195A, Hurst and Brick. And then a little earlier, at internal page 193D, PDF page 521, Lord Millett said the doctrine of accepted repudiation is of general application in the law of contract, and there is no reason why it should not apply to an agreement to enter into partnership or to the contractual obligations which the partners mutually undertake to observe after the partnership has come to an end. But I have considerable doubt that it can be employed to bring about the automatic dissolution of the partnership itself. So he wasn't excluding the possibility of the doctrine applying to partnerships. Just not, you can't dissolve a partnership that way. And coming on to this point about lack of knowledge by Mr. Hughes, because that's the point that learned friends make against us in paragraph 97A. If one accepts that the doctrine of accepted repudiation does have a role to play in partnership relationships, then we say that it would be open to the court to apply the principle in Boston Deep Sea Fishing and Ice Company, Ansell, and you know, that's the one that you can rely on a serious breach. That was an employee-employer case, and the employer at the time when they dismissed the employee didn't have proper grounds to dismiss him, but actually there was another ground which they found out subsequently, which would have given them proper grounds to dismiss him. And the result in Boston Deep Sea Fishing and Ice Company and Ansell is that the employer was entitled to rely upon a ground that he didn't know about at the time they dismissed the employee.
Deciding to
Dismiss him.
insisting a claim for wrongful dismissal.
Yes. Now,
So why isn't that analogous to saying when the court is, or when an account is taken between the partners, one partner may be able to rely upon something which he didn't know about at the time to adjust the account?
well, I don't have any problem with that, my lord, save for the fact that that's not how the judge treated the issue in his judgment.
Yes, but what I'm saying I think, sorry, are you still on your first point about the duties change?
Yes. Well,
So why is Boston Deep Sea Fishing a good analogy for the proposition that it's not just the working out of the account that can take account of the something that wasn't known, but actually that the duties changed at an earlier term?
Well, I think you'd say, wouldn't you, that it's authority for entitlement of the employer to sack the
Yes.
employee without notice.
Yes, and yes,
In that sense,
and there would be no further
yeah.
obligations owed by the employer, and it has been applied in a partnership context. That's the case of Complete Care Services, which is at tab 59 of the bundle. I mean, this isn't a dissolution case, but kind of similar in a way, because the issue in this case was whether a partner could rely upon a ground unknown about at the time that the partnership expelled a partner, so unknown about at the time of the expulsion notice, to justify the expulsion. And it was argued at paragraph 53 of that judgment. Just in passing, just note paragraph 33 where counsel for the expelled partner, Miss Anderson, Casey, accepted that all these were mutual obligations to act in good faith, not to place oneself in a position where one's own interests or the interests of others might conflict, and so on and so forth. And then one moves on to paragraph 53. It starts at paragraph 50. Another of the legal issues the court has to determine is the extent to which one partner who purports to exercise a power to expel another may seek to rely upon grounds additional to or differing from those stated in the relevant expulsion notice. It's well established in the case of employment contracts that an employer can rely upon grounds for dismissal that existed at the time of the dismissal but were only discovered subsequently. The question is whether this principle applies in the context of a partnership agreement as well as in the employment situation. Mr. Chapman submits it does, and Mr. Anderson contends otherwise. And then Boston Deep Sea is cited by the judge, and then and particularly the judgment of Lord Justice Cotton, who said it was not, I think, at all disputed that if there was any circumstances, though unknown to the company at the time when they dismissed Mr. Ansell from his position, which would justify them in so acting, it was immaterial whether that was known at the time. And if it was known and established after the time the action was brought, then they could justify the dismissal by proof of that fact. Mr. Chapman emphasises Lord Justice Cotton's reference to any circumstance and not just a new ground. and then at paragraph 53, Mr. Anderson accepts as a general proposition in wrongful dismissal claims derived from Boston deep sea fishing case that facts which were available to one party as grounds for dismissal but which were not relied upon at the time can be relied upon to justify dismissal. However, she submits that the principle cannot apply here. Unlike those cases, the relationship between the parties here was admittedly a fiduciary one, and Mr. and Mrs. Godwin were obliged to act in good faith. She argues that it's difficult to see how reliance upon a ground, the relevant facts of which were not known to them or appreciated at the time, can be acting in good faith, especially given the seriousness of the consequence for CCS of the decision that was being taken. Nor would it be fair to an expelled partner for the court to allow an expelling partner to rely on facts, matters, circumstances that they had only found out subsequent to the expulsion. To do so, Miss Anderson said, would offend against the need for certainty. And in response, Mr. Chapman submits that it's difficult to see why the duty of good faith between partners should make any difference. During the subsistence of the employment relationship, an employee owes duties of fidelity towards their employer. Moreover, the duty of good faith between partners is a mutual one. If an expelled partner has hidden any misconduct from the expelling partner, it's difficult to see why, when this is discovered, it should not be capable of being relied upon.
Do we need to read the submissions?
No,
Because
no.
the judge
Just
comes
at
to
the
the
end.
point at 57, 58.
Yes, exactly, and he agreed. In principle, I accept Mr. Chapman's submissions for the reasons that he gives. I hold that the principle applied in Boston deep sea fishing case is a general one. And at 58, the duty of good faith between partners doesn't affect the position. The duty is a mutual one. And so, yes, that was a case on expulsion, but we say that there's no reason why it shouldn't apply in a case where the partnership has been dissolved because the partner doesn't trust the other any longer. And it transpires that although he was suspicious, he wasn't quite able to put his finger on all the reasons why he was suspicious, but it transpires later that he finds out another ground on which he was absolutely justified not to trust his partner and to serve a notice of dissolution. I think I've already made this point, but just in case I haven't, even if that's wrong, even if you have to know about the breach, as at the date of dissolution, Mr. Hughes had identified that Mr. Manduka had diverted a number of leads. My learned friends point out that the judge found that Mr. Hughes' belief that Newfoundland's success was driven by Mr. Manduka's diversion of leads to Newfoundland was wide of the mark. But that finding, and it, I think one can absolutely accept that Newfoundland had success on their own terms, in their own right. I mean, those two young men were phenomenally successful. But that doesn't detract from the fact that Mr. Manduka undoubtedly did divert leads in circumstances that were unjustified and in breach of his fiduciary duty to Mr. Hughes. And the judge did so find. And of course, diverting business away from the partnership that had the effect of depriving the partnership of the full profit to which it would have been entitled, or could have been entitled, if the lead hadn't been diverted to Newfoundland.
But isn't the response to that, which I think the judge would have ordered, is accounting for, on the part of Mr. Manduka, for the profits, for the secret, both for the secret profits and for those diversions that were found to have occurred?
Well,
why didn't you say that's the answer?
Well, on one level, you can say that that's the answer. On another level, I do say that that's really not a sufficient response of a court of equity in circumstances where the one partner has breached his fiduciary duty to the other so seriously. Because look at the result here. The result here is Newfoundland it was agreed that Newfoundland could go direct to ACON from the 14th of June. So from that date, the partnership had no claim against Mr. Manduka for any secret profits he was making out of the partnership, because the relationship between the partnership and NFL had ceased. But at the same time, Mr. Manduka went on and continued to receive his 30% of the profits. So he, I mean, you know, and it.
Okay,
was-
no, I got that point.
Yeah.
That's, if you like, the second.
Yeah. Yes, that is, you're right, it's the discretionary, it is the discretionary point. So our skeleton does mention the case of the Plus group, which was we referred to by way of analogy, because that was a case where a director set up a competing business, and the court held that he didn't have to account for the profits of the competing business, because by the time, although he remained a director, by the time he set up the competing business, the court held that any position within the firm that he had as a director had been reduced to vanishing point. Now, it's not exactly the analogy is not exactly the same, but looking at it, what happened in this case objectively, and this is saying why Mr. Hughes didn't any longer owe any fiduciary duties. By the time he dissolved the partnership, the partnership relationship had been reduced as a consequence of Mr. Manduka's conduct to vanishing point. There was no relationship anymore.
I mean, of course, once you serve dissolution, there isn't going to be a continuing relationship anyway. It's a matter of
Well,
winding
no,
up the
I do
business.
see that. I do see that. But you can have a partnership can be dissolved, but the partners are expected to be able to work together, and you can still have a cooperative relationship. But in this, on the facts of this case, that was never going to be possible. A case which we mention in our skeleton is a case called Riley and Walsh, which again contains a sentiment which is effectively it could be seen as the court exercising its equitable jurisdiction not to grant relief, but that's not quite how the judgment is framed. So that case is at tab 69 of the bundle. The facts were, it was a two-partner firm of carpenters and builders, two brothers, and they entered into an agreement, that Edward and Oliver Walsh entered into an agreement with a developer to purchase land and build on it. One of the brothers, Oliver, got into disputes with the developer and went missing, and then became insane and died. And Oliver bequeathed his interest in the property to a Mrs. Riley, that's why it's called Riley and Walsh, who issued a claim claiming that there was a partnership. And at page 28 internal of the judgment, page 2063 of the...
Do you want us to go to this?
Yes.
Oh, sorry. I mean,
Sorry. Well, only or you can just listen to what he said. I mean,
I was listening,
yeah.
but
Well, then you don't need
get
to,
a bit
because
further.
no, because it's not a lot. The original intention was to form a partnership. This is what Baron Richards held. But has that ever been carried into effect in such a manner as to entitle the plaintiff to treat the speculations as being still a partnership transaction? What occurred in the lifetime of Oliver Walsh, whom the plaintiff represents, warrants no such conclusion, but the contrary. From the very commencement, his conduct was the very opposite of what it should have been if he intended to act as a partner fairly, with the consequence that after such conduct, his representative, the plaintiff, has no equity to call on the court to prevent the operation of the rule of law. And then there's the case of Purdon and Miller, which is a South African judgment, which is at tab 70 of the bundle, where a Justice of Appeal, Olga V. Thompson, this is at internal page 230, G to H, said that a partnership is a contract uberami fidei, and in my view, that connotes that a partner wishing to invoke against his co-partner the stringent provisions of a summary cancellation and forfeiture clause contained in the partnership agreement must at least himself be honouring the terms of that agreement. In my judgment, the equitable principles of our law do not permit a partner who is himself repudiating his partnership obligations towards his co-partner to enforce against that co-partner a forfeiture clause. What that case was about was that a partner, Mr. Purdon, first denied the existence of a partnership entirely. The partnership was in a pineapple growing farm, and then sought wrongly to invoke the forfeiture provisions in the partnership agreement, which would have denied the other partner compensation in respect of his interest in the pineapple farm. The point about that case, though, is that the judge makes clear, and that's really the principle that, one of the principles that we're relying on here, is that the court is not going to assist a partner who wants to invoke the stringent provisions of the compliance with fiduciary duties in a partnership relationship if the partner seeking to invoke those stringent provisions is not complying with his obligations. So, and to me on partnership, that's tab 101, paragraph 1557, page, PDF page 2344, reminds us, just prior to discussing Riley and Walsh, that the fiduciary duty owed by one partner to another is reciprocal, and it follows that where one partner refuses to carry out his part of his duty towards his partners, he does not have a cause of action against the other partner if they fail to comply with their fiduciary duties towards him. I mean, one can say that those cases are the expression of the court's equitable jurisdiction to deny relief to a co-partner or to a partner who has not performed his duties to his partner. Now, I'm acutely aware that in recovery partners, that's at tab 64, Lord Briggs at paragraph 16 said that the essential purpose of the rule that a fiduciary must not without his principal's consent keep for himself a profit from his position as such is to protect or deter those who have undertaken an obligation of single-minded loyalty to someone else for being tempted by human frailty to fall short of that obligation. But in the context of partnership, on what possible basis can it be said that by requiring Mr. Hughes to pay any part of the profits that he made post-dissolution will help to deter those who have undertaken an obligation of single-minded loyalty to someone else from being tempted to fall short of that obligation? On the contrary, we say, requiring Mr. Hughes to pay part of his post-dissolution profits to Mr. Manduka is in fact a positive encouragement to disloyalty and breach by persons in Mr. Manduka's position, because they risk no real sanction. and to require Mr. Hughes to account to Mr. Manduka produces an objectively wholly inequitable result, which the judge seemed to accept at paragraph 440 of his judgment, when he was considering whether Mr. Hughes' wife had dishonestly assisted Mr. Hughes in a breach of fiduciary duty. He said at paragraph 440, I've concluded that while they were mistaken in their belief that they could properly use the partnership and Newfoundland's contacts, I don't know why he said Newfoundland's contacts, that had nothing to do with it, but anyway, to continue a business of selling ACON tests post-dissolution without accounting to the partnership for benefits they received, their acts were not dishonest by reference to ordinary standards of morality. They genuinely believed that they were acting appropriately and defensively in response to what they saw as the Manduka's mendacity. This belief did not represent the application of any particular warped moral code. A person applying conventional standards of morality could have thought the same. Well, given what the judge found, it was strange that he felt, notwithstanding that a person applying conventional standards of morality wouldn't have condemned Mr. Hughes for what he did. He nevertheless concluded that Mr. Hughes still had to account. And whereas I can see that in the context of fiduciary relationships where it's all one way, the courts are concerned to make sure that the fiduciary isn't in any way tempted to prefer himself over the party to whom he owes loyalty, a continuing obligation of loyalty. In a case of partnership, it is fundamentally different. And if one partner is being disloyal to the other partner, there is no conceivable reason for insisting that the other partner should nevertheless still comply with his fiduciary duty. And case law is there to assist the court to give relief in cases where there are fiduciary duties in play. For example, in the case of Murad and Al-Sarraj, which was cited in Foster Bryant Surveying and Bryant, which is at tab 39. We haven't got the actual Murad and Al-Sarraj case in the bundle, but the extract is in Foster Bryant and Bryant at tab 39, paragraph 77 of the judgment, where reference was made to considerations that equitable principles should not be permitted to become instruments of inequity. And also in Chan and Sakaria, that case that has been cited repeatedly, if one reads on in the judgment from the extract that has been relied on repeatedly by the courts, this is at paragraph 30 in tab 72 at PDF page 2117. As I say, as we've seen earlier, the case of Chan and Sakaria has been cited repeatedly with approval in this jurisdiction in connection with Section 29 post-dissolution cases. And of course, Chan and Sakaria was a post-dissolution case. He said at paragraph 30, many of the statements of general principle requiring fiduciary to account for a personal benefit or gain are framed in absolute terms, inflexible, inexorably, however honest and well-intentioned, universal application, which sounds somewhat strangely in the ears of a student of equity, and which are to be explained by judicial acceptance of the inability of the courts in much the greater number of cases to ascertain the precise effect which the existence of a conflict with personal interest has had on the performance of the fiduciary duty. The principle is not, however, completely unqualified. The liability to account as a constructive trustee will not arise where the person under the fiduciary duty has been duly authorised. The right to require an account may be lost by reason of the operation of other doctrines of equity such as late cheese and equitable estoppel, it may still be arguable in this court that notwithstanding general statements, the liability account for a personal benefit or gain obtained or received by use or by reason of fiduciary position, opportunity or knowledge will not arise in circumstances where it would be unconscientious to assert it, or in which, for example, there is no possible conflict between personal interest and fiduciary duty. In that regard, one cannot but be conscious of the danger that the over-enthusiastic and unnecessary statement of broad general principles of equity in terms of inflexibility may destroy the vigour which it's intended to promote, in that it will exclude the ordinary interplay of the doctrines of equity and the adjustment of general principles to particular facts and changing circumstances, and convert equity into an instrument of hardship and injustice in individual cases. There is no better mode of undermining the sound doctrines of equity than to make unreasonable and inequitable demands of them, citing Lord Selborne in Barnes and Addy. This is an exceptional case. As I said earlier, it must be exceedingly rare that a person who has committed a fundamental breach of his fiduciary duty by making a secret profit, which is how Lord Wright described secret profits in Regal, Hastings and Gulliver, as well as having committed other breaches of fiduciary duty, has the audacity, I would say, to come to a court of equity and ask it to compel the injured party to pay him. We've demonstrated by reference to early case law that the courts of equity did not assist those who breached their fiduciary duties. Justice Dean also, I suggest, makes a very powerful case for not applying the full rigours of equity where it's unconscionable to do so. And we say it's unconscionable to do so in this case. So, in summary, our case on ground 1E is post a fundamental breach by a partner, the other partner post dissolution is absolved or released from any further duty of loyalty, good faith or fiduciary obligation. Alternatively, even if Mr. Hughes was not released, Mr. Manduka, while himself in serious breach of duty, had no standing to come to relief, to come to a court of equity for relief. Alternatively, if Mr. Manduka is found to have standing, a court of equity has jurisdiction to deny Mr. Manduka relief on the ground that it would be an affront to conscience for the court to insist that Mr. Hughes owed a continuing duty of loyalty to Mr. Manduka post-dissolution. It would, to make such a finding, it would have the consequence that the equitable principles of good faith will have been converted into instruments of inequity. So we ask, therefore, for the court to overturn the judge's order in relation to section 29 and to declare that Mr. Manduka isn't entitled to a penny piece of the profits that Mr. Hughes earned post-dissolution from his own hard work. A final point that I didn't make, which I must do in relation to the Danish deal, because that is Mr. Manduka's target. There was no evidence before the court that Mr. Hughes breached his fiduciary duty in connection with obtaining the Danish deal. And it was not a finding, it was not a finding by the judge that in obtaining the Danish deal and obtaining profits from the Danish deal, he breached his fiduciary duty. The judge found a duty to account on the part of Mr. Hughes solely on the grounds that ACON was a business connection and that he therefore had to account on that basis. My lords, my lady, my learned junior is now is going to address you on section 42, and then I will come back on the last short grounds. I'm just wondering whether we could rise early and come back early, rather than
that may make sense actually, because I know my lord needs to rise by 5 to 1. I don't know what time he needs. It's the earliest he could be back.
I was planning to get back at two,
At 2.
but I can probably push it quickly if it's needed.
Do you know, rather than waste time, since my optimistic assumption of yesterday morning has proved to be ill-founded,
I'm sorry.
perhaps if Miss Rogers wouldn't mind starting for 5 minutes, we won't be wasting any time.
My lords, my lady, I'm going to address you on ground 2 of our grounds of appeal. And what I'd like to begin by doing is giving a summary of what the appellants say about ground 2 before moving into detailed submissions. In short, the appellant's case on section 42 of the Partnership Act 1890 is that in order that section 42 be engaged, there are 4 clear requirements, and I will take your lordships and your ladyship to the wording of the Act in my submissions, but in short, there is an outgoing partner. And secondly, there are surviving or continuing partners or partner. Those surviving or continuing partners carry on the business of the firm with its capital and assets. And finally, number 4, there is no final settlement of account between the firm and the outgoing partner or his or her estate. And the appellants say that section 42 was not engaged on the facts of this case. Now, in setting out the summary, I would like to, if I can, pick up the appellant's skeleton argument at this point and just address one point on our position as it's put in the skeleton argument. That's at tab 3 of the core bundle, at page 55, where we begin to deal with ground 2. And in particular, over at page 56, I'd like to draw the court's attention to paragraph 80 of our skeleton argument. We say there that Mr. Hughes advances 2 contentions under ground 2A. However, on reflection, this is better viewed as 1 contention. We are not taking the point, which appears in the 3rd sentence of paragraph 80, that section 42 does not apply in the case of a general dissolution. We're not taking that point. We maintain, of course, because it's the entirety of ground 2A, that outside of cases involving death, for section 42 to be engaged, there has to be an outgoing partner who has been excluded. And that is said in paragraph 80, and we retain that. But that is also said in paragraph 81, and that is part of the 2nd contention. So that's why I say that actually on reflection, given the point we're not pursuing, this is really just 1 contention.
And doesn't apply in the context of a general dissolution in the light of authority or just because it can't?
In the light of authority.
Yes, I see.
Cathirana was a case of a general dissolution in which the Privy Council did consider that section 42 could apply.
Yes, I see.
The judge's conclusion, I think it's helpful to have it in mind before I launch into my submissions on section 42. The judge's conclusion on section 42 can be found at paragraph 423 of the judgment. That's tab 9 of the core bundle, page 172. And as the court can see from paragraph 423, the judge saw no logical difficulty with the proposition that both Mr. Hughes and Mr. Manduka could both be carrying on the business of the partnership for their own respective accounts following dissolution. we say there is a logical difficulty with that proposition, because that is not what section 42 says, and it is not what section 42 means, and it does not apply in those circumstances.
And that
as
probably is
described.
going to be a convenient moment to let my lord go. Can I just ask you, is it accepted that the carrying on of business was with the partnership's capital or assets?
In this matter, no, that's not accepted,
Some of them.
because it has to be the business.
And is that a point that's aired in the skeleton?
Yes, that is a point. Essentially, the way we make that point is that section 42 requires the carrying on of the business of the firm with its capital and assets. And we say in our skeleton that either neither partner was doing that, or both partners were doing that, depending on whether the judge's finding stands or not. And I'll come to address the court on that, whether the judge's finding can stand. And in either circumstance, we say section 42 is not applicable, because section 42 very clearly applies where there is an outgoing partner.
I see that. I'm not sure that quite deals with the question of capital or assets, but perhaps we can come back to it.
Yes, I think the answer might be in part, but not sufficient to satisfy section 42.
We'll stop now, and I think we'll start again at 2 o'clock to give my lord a little leeway.